Hello, my name is Craig Altman, founder and president of Tradition Software and Tradition Lien Service, headquartered in the suburbs of Chicago and beautiful Warrenville, Illinois. Today, I want to talk to you about construction lien law for the great state of Oregon. I have driven from the California border up through Oregon on my way to Seattle in the past, done business in downtown Portland and the surrounding suburbs, and I've been very fortunate to play golf at the Great Bannon Dunes Golf Resort in southwestern Oregon. Before I talk about construction lien law for Oregon, though, I have to give you our standard disclaimer, and that Tradition Software, Tradition Lien Service, and myself makes no warrant, express, or implied for the use of this video, our websites, our software, pre-lien to lien, or the documents prepared by Tradition Lien Service. In no event shall Tradition Software, Tradition Lien Service, or myself be liable to anyone for any problem, claim, or loss arising out of the use of our videos, websites, software, document preparation services. Tradition Software, Tradition Lien Service, and myself are not engaged in practicing law in the state of Oregon, nor does Tradition Software, Tradition Lien Service, or myself provide legal advice in the state of Oregon. Okay, so I'm going to share my screen right now, and I'm going to talk a little bit about construction lien law for the state of Oregon. I think the first thing that we have to take into consideration is that, first of all, Oregon is a state that does require a first notice for subcontractors. And I can get to my Oregon laws by going to the state deadlines drop-down menu here and selecting alphabetically Oregon at traditionsoftware.com. And then also too, on Tradition Lien Service, I can go to state deadlines and select the state of Oregon here. So if you are a subcontractor in the state of Oregon, your time frame to send out a first notice, which is called in the state of Oregon a notice of right to lien. And that time frame is actually a very short time frame in terms of sending out this notice. You have really only 8 days after the first day of providing the delivery of materials or providing equipment, labor, materials, or services. Okay, and that is according to Oregon Revised Statute Section 87-023. Now we're strictly talking about private commercial projects or also to existing residential or new residential projects. And again, let's define what a subcontractor is. And a subcontractor is somebody supplying equipment, labor, materials, and services for a project who is not in direct contract with the property owner. And in this case, the property has to be commercial property that's not owned by a city, county, state, or authority, or existing residential property or new residential property. And again, the notice that needs to be done, which we can do for you as a service for $26 at traditionlienservice.com, or you can print it by leasing printing to lien for as little as $164 in the first year. That notice is that notice of right to lien here. And you can see it's addressed to the property owner, of which you're going to want to send it by certified mail to the property owner. And you can send it then by regular mail to your general contractor and your customer in the project. Okay, and what you're doing with the notice of right to lien is simply establishing the future right to a construction lien in the future. Okay, now, if you are on a project and you don't get paid for that project, you can certainly consider doing a lien warning notice in Oregon. Now, Oregon is not a state that requires a warning notice, unlike residential projects in nearby Nevada or other states in the U.S. It's strictly going to be a bluff notice, as we call it here. And here is an example of what's going to go out. And if you send this by certified mail to the property owner and also to, maybe the bank on the project and to your customer, you'd be surprised that there's going to be about a 25 to 33% success rate in getting paid, especially when you say there's basically a 10-day deadline that a claim might be filed, okay, if you don't get paid. So do consider doing this. we can do it as a service for you for $50. It's sent by certified mail to the owner and by regular mail to everybody else. Or you can also, again, print it out of pre-lien to lien. Okay. Now, if you get to the point of needing to do a construction lien, you again have a shorter time frame than other states in that you have a 75-day deadline after the completion of providing equipment, labor, and material services of the project, or 75 days after the completion of the entire project. Now, many of your states, especially your Western states, give you 90 days, such as California or Nevada or Arizona, for example. You don't have as much time in Oregon, just like you don't have as much time to send out a first notice. A first notice really needs to go right out at the beginning of a project, and that, you have to do it within 8 days. So Oregon does shorten the time frames for you to do it. Okay. Now, an actual claim of construction lien in the state of Oregon is going to ask you for a breakdown of your demand or what is owed to you. So it's not only just the total that you need to break down, but you need to be prepared also to illustrate what your breakdown of equipment, labor, materials, or services are for the project. And in this particular lien example, it was just materials that were supplied, and that's perfectly fine. This lien was recorded in Deschutes County by the county clerk there, and it's the county clerk's office in Oregon where you are going to do your lien recordings. This lien is a couple years old, but back in 2019, it cost $82 to record a lien with the county. And if Traditional Lien Service was to do this lien for you, we would charge you $170 for basically a 1 to 2 day e-recording of the lien. And then we're simply going to pass the county recording fees on to you at cost. And both Oregon and Washington have much higher, or have higher rates than a lot of the country, though California has also gone up with their rates the last few years. But you do need to be prepared for, paying both a recording fee and then our service fee if you are asking us as a service to do the recording. Finally, if you are paid on the project, you cannot just do a standard conditional or unconditional waiver and release. You need to, again, go to the county or e-record with the county an actual satisfaction of construction lien so that the title for the property is cleared. And it's going to ask you for the instrument number, and the instrument number is going to be assigned to you by the county with typically a year dash item number or a document number or instrument number when it's recorded. And you are going to need to get this notarized also too. Don't try to release a lien without it being notarized. So here is the notary information here that's on your lien. Now, we would love to work with you at either Tradition Software and leasing our software solution pre-lien to lien, or at Tradition Lien Service. We can be reached Monday through Friday from 8 a.m. to 5 p.m. Central Standard Time, Central Standard Time. And our 800 number is always 800-886-8770. More often than not, you're going to get me on the phone, and I'll be more than happy to offer you a real quick 5-minute opinion about how we might be able to help you. And if we can't help you, I'm also going to give you an honest answer. Keep in mind, I am not an attorney in Oregon, so if I have to, I will refer you to an attorney or suggest that you go to an attorney. And then also to keep in mind that if it's a public works project, we can help you also too with bond claims and stop notices. And I'm not going to talk about that in this video, but that is something we can help you with also through our software and through our service. We appreciate you watching this video. Have a good day.